So this is not another conversation about GDPR. It is a conversation with a lawyer who deals with data issues. Our guest today, Ian de Freitas, is a litigation and compliance attorney with over 30 years of experience. Our conversation jumps all around the place, but we managed to talk about a few topical issues in the data realm. One being the Lloyd versus Google ruling that happened in the UK, and the other being Project Red Card, where footballers, aka soccer players, are protesting or suing over the illegal use of their data by booking and gambling agencies. So in case you are wondering who Ian is, let me give you a bit of background on him before we start. He leads Ferrer & Co.'s data, IP, and tech disputes team. He assists clients in responding to breaches of data protection laws and regulations and follow-on litigation, and also advises on compliance issues in the area. His work often crosses borders. He's based in the UK, but he likes to work with the US on some of their stuff. And he was recognized as one of the leading litigators in the UK in the Lawyer Hot 100 in 2011 for his work helping a client recover a vast amount of data that was and information that was unlawfully taken from him. We actually touch on this in the conversation, and I ask him what he sees and how that ruling plays out with the greater ecosystem of data porting and data stealing, we could say. So last but not least, he was past president of the IP Commission of the Union Internationale des Avocats, an international organization of lawyers, as well as a member of ITech Law. In case you have not ever tuned in before, I am Dimitrios Brinkman, and you are listening to Are You a Robot? Last but not least, before we jump into the full conversation, I want to thank our sponsor. EthicsGrade is doing some incredible stuff around ESG ratings. In case you don't know what ESG ratings are, that's where a company will look at other companies and rate them on the non-financial impact they have in the world. So EthicsGrade is doing something pretty significantly different than other ratings companies, because they're looking at AI programs and ethics programs within these different companies that we know and love or hate and use every day. They also look at data governance programs, and they factor all of these different pieces in together to give companies a scorecard, which you can go and check out at ethicsgrade.io. Right now, you can download a scorecard for free and probably get surprised at some of the scores that companies we use are getting and they're receiving. So check that out at ethicsgrade.io, or just click the link below in the description. And without further ado, our conversation with Ian.
Are you a robot?
All right, Ian, it's great to have you on here. I want to talk to you about so many things, and this, I feel like, is going to be a really in-depth conversation when it comes to the way that data is used and abused, which is one of my favorite topics. But we also were just saying before we hit record that we're going to be free, and we're going to let it take us wherever it may take us. So that's the idea we have right now, and we'll see how well we do when we get to the end of this recording, and we'll be able to grade ourselves. But I'm super excited to have you here. I know that many people are probably interested in how you came to be a lawyer that is primarily dealing with all of this data stuff. And as we all know, in 2022, data is quite messy. So I'd love to hear a little bit of the run up to and your journey thus far.
Okay, so I mean, I became a lawyer way back in 1990. So, and the internet was just sort of kicking off in the 90s, and so I was there when we were trying to work out what it all meant for the law. And I started off advising people who were setting up, platforms and a lot of it was about that and the intellectual property rights. But pretty quickly we got onto, okay, there's lots of data here. What are we going to do with this data? Who owns this data? And it was pretty freewheeling to start with. But as we got into the sort of the second decade of this century, it started to become a problem, and people recognized that. And really, the catalyst was the Edward Snowden allegations and the Edward Snowden revelations in sort of 2013, 2014, which really ramped this up for everybody, where everybody was saying, there's a hell of a lot of data out there. We don't know what's happening with it. We think the US government's getting hold of it and various other people. And also there's a lot of data held by people like Google, Microsoft, etc., all the big tech companies, and we're losing control. So let's try and get the control back. So my work in this area as a lawyer really started in earnest around about then. And of course, we could talk about this, but we then had GDPR, the European legislation. We've had other bits of legislation around the world. So it's become a hot topic, a lot more regulated, and lots of legal claims have arisen out of all of this. So that's sort of the journey, if you like, to where we are now and sort of where I am. And this is pretty much 75% of my time is taken up with controversies around the use of data connected to the sort of issues we're talking about. So it's hot for me.
I can imagine there's never a dull moment when it comes to the controversies around the use of data.
I'm always asked questions. Well, what's the answer? And unfortunately, I sometimes have to say I'm not sure. I think it's this, because the way the data is being used and technology is developing, there's so many new applications, and it's difficult to work out what that means for the law and for people's rights, and also the rights of the companies that are using that information. So it's constantly evolving, and that's why it's interesting.
So do you feel the law has not been able to keep up?
Yeah, pretty much. So what we've often had to do in the past is sort of take old laws and try and match them to the technology. And then eventually, legislatures and courts catch up with that, and they come up with some ground rules. But we're constantly chasing our tails. So at the moment, all around the world, we're trying to deal with sort of online harms issues. So we got some legislation in the UK about that. And there's some European legislation which is coming through. The problem with a lot of that is that once the legislation comes in, it's often outdated. So you're then playing catch up again, and then the courts are having to interpret that legislation, apply it to new situations. So it is a constant battle to try and keep up.
So with something like online harms, one thing that always fascinates me with that is I know there's the thing that happens sometimes when someone gets doxxed or they get swatted. And that's basically, for those who don't know, it's when someone online gets a hold of your physical home address, and then they call they call the police and say there's something really bad happening at this address. And the police, and this is primarily, I've heard about it in the US because the US loves to use their police force for whatever. And so then they send out the SWAT team, and then the SWAT team, you can imagine somebody that's not really doing much, they just get broken, their door gets banged down, and the SWAT team comes in, and it's guns blazing, hands in the air. For someone who has just pissed off another person on the internet, and that person did not feel, the person just who was wronged, it's very harmful for them. And it's just not nice to think about. But what I always am trying to figure out is, how can you get justice for this person? And not to mention, there's a lot of resources that go into like deploying a SWAT team to somebody's house.
Yeah. I mean, that's an extreme example, but I mean, what I come across in day-to-day practice is not so much that sort of physical interference with people. It's more sort of the psychological damage which is caused by adverse comments, targeting of people online, fake sites set up to sort of damage their reputation. It's that sort of thing. The problem is that if somebody who is pretty sophisticated is doing that, it's very difficult to find them.
That's it.
And so where this leads us to is where we're all going, I think, which is to say to the internet hosts and other people who set up these sites which are being used for these purposes, that they've got to police them a lot better, and they've got to be a lot more proactive about making sure, or trying to make sure, this sort of thing doesn't happen. But it is a constant problem. People sort of using fake sites to send around fake information about people. And your example is an extreme one, but much more day to day. I do see it in relation to the psychological harm that it causes to people, and it's really quite significant. And it's difficult to ignore when you're in the eye of that storm.
Yeah, and so basically, you're saying the responsibility needs to be put on these private companies and businesses that are.
I mean, that's the way we're going, because we simply can't seem to sort of get to the root of the problem by getting to the people who are actually doing it, the main perpetrators. So that responsibility then falls on the hosts, the private companies that are hosting this material. The problem with that, of course, is that where does the line go between what is harassment and what is free speech? And why, how is it right that we expect private organizations to be determining, organizations like Twitter, for example, to be determining whether or not this is acceptable speech, or whether it flows over into hate speech or other things that the law would say is unacceptable. But that is where we are going, certainly with the current legislative sort of agenda that we're seeing pretty much globally.
Well, and it's already happening, right? Like if you look at people being censored on YouTube for talking about certain things, or people that are being kicked off of Twitter for talking about other things, a lot of people may think that's a good thing, but then, like you said, it is also very difficult to start to think, okay, now Twitter is the one that decides what is right and wrong. So the power that is put into their hands is a little bit scary. But then also, how else could we see this? Like, have you thought through what would be another option?
I mean, the other way to potentially do it is to make it clear that if people are going to use these platforms to comment, they have to be identifiable. Problem with that is, of course, that and therefore that the platform can then put them in touch with the people who are complaining, and they can sort it out between them. The problem with that is obviously that sometimes people quite rightly want to speak anonymously for very good reasons. So I don't have a look. If you're asking me, have I got a silver bullet for all of this? If I did, I'd be a very successful lawyer. Probably I'd have more clients.
You wouldn't be talking to me right now.
I am not that. Yeah, I am not that clever. But I think the current system, which is that the platforms have sort of said, well, it's nothing to do with us, and therefore walked away from it, has failed. I think everybody accepts that. And so I think we are going into this area of making them responsible. Now, what happens with these things is you get these regulations coming in, and they're often deliberately vague because nobody's quite sure about where they're going to go. But then you get the courts coming in, and the courts interpret them. And after a while, you sort of get to settle down into a practice which people generally find acceptable. I mean, that's what's happened with a system called notice and takedown, which has been around for many years in the States and also over here, where you would serve a notice and say, please take this down. And then the courts began to interpret what that meant. And they've sort of come up with a pretty stable arrangement now for what that means. And people understand what it means, and therefore how they need to respond to that. So it's unusual to get a straightforward answer to a difficult problem. But over time, you sort of develop a practice which most people can live with.
All right, so let's change gears a little bit and talk to me about Lloyd versus Google.
So Lloyd and Google is a very interesting case, and it engages with all of this because
recent
it is
too, right?
Yeah, very recent. A ruling in the UK Supreme Court in November, so very recent. Everybody was waiting for this because it was setting some very important ground rules, and the ground rules were about what can individuals do when their data has been misused by a big tech organization, in this case Google, to enforce their rights through the courts. And
misused here means that it was sold, or
no. Okay, so I'll explain what the background was. So the underlying allegation was that Google had been tracking people's online activity. They've been using something called the Safari workaround to bypass some privacy settings on iPhones. This went back to sort of 2011, 2012, and that had been suggested to have affected about 4.4 million people in the UK, so very significant number of people. And the allegation was Google had then used the data, that the browsing data that they gathered, to use it for targeted advertising to people. So the usual model: get the data, you target the advertising at people, what they're apparently interested in. And so, you know, when people found out about this, they weren't very happy about it. And there was an earlier case, but that was just a few people involved. But anyway, there was a guy called Mr. Lloyd, who's a bit of a consumer champion, who came along in 2017. That date is important because if he hadn't brought the claim then the time limit for bringing claims would have run out. So 2017, he starts a claim against Google. And he not only claims on his own behalf, but he claims on behalf of all of the 4.4 million affected individuals. And he does that under a special rule in English court procedure, which is called a representative action. That's where one individual can come along and say, I'm representing all of the affected class of people, and I'm going to claim compensation for all of them. And if I get compensation, then I'm going to, you know, pay it out to them.
And these people didn't have to know. They didn't have to say, yes, you do this and I elect you.
Correct. They didn't have to, as we say, opt in. They do have the right to opt out once they find out about it. So they can say, they can go to Mr. Lloyd or his lawyers, look, I don't want to be part of this, take me out of it. So it's as I say, it's this representative claim where people have to opt out if they don't want to be involved. The issue was that you can only do this where you're representing the 4.4 million people who have the same interest. So they've got to have all the same interest in the claim. And in this
case, means,
it means that they're all affected in the same way, and they're all effectively claiming the same type of compensation. So in this case, Mr. Lloyd said, look, 4.4 million people, they've all had their rights deprived. And I say, Mr. Lloyd said, I say that is at the lowest common denominator. All of their rights have been deprived, and therefore that lowest common denominator, they've lost control over their data. So just losing control over their data entitles them to some compensation. And I'm going to say it's £750 each. So if I win, Google, here's a bill for, well, you work it out. It's over 3 billion.
3 billion for four.
So very significant sum of money for Google. And also, this is a test case, right? This is the first time this case has been tested in the English courts. So very significant.
Because then presumably Facebook would be next, Twitter would be next.
I mean, there were lots of claims waiting in the wings for this decision. So there's one pending against TikTok. There's one pending against Facebook. There's another one involving Google again. So, I mean, there were lots of these claims knocking around, waiting for this decision. So we were all on tenterhooks, waiting to see what the court said in November. Do you want me to tell you what they said?
Well, I mean, I've read the blog post, which we'll link to also in the show notes. But yes, please don't leave us hanging.
Okay, so Mr. Lloyd lost, basically. So Google won this round anyway of the fight. And the reason why Mr. Lloyd wasn't allowed to pursue his claims was for two main reasons. First of all, the judges said that simply losing control over your personal data isn't enough. You've actually got to suffer some sort of damage in terms of, financial loss or whatever, in terms of what the data was used for, or alternative, you've got to show you're distressed, so pretty upset about what had happened. And Mr. Lloyd made no claims about that. All he said was just taking away the rights entitled to compensation. Court said no. Second reason, not everyone had the same interest. What the court said was that, look, if you're getting browser information, it could be that some people were only looking at stuff momentarily and then, they left the site. Some of them could have been tracked for days, weeks, or months. And also what they were looking at could be quite sensitive for some of them, but some of it might be very anodyne. So not everybody would be entitled to the same type of compensation for that. And therefore they don't have the same interest. You can't use this mechanism. So sorry, Mr. Lloyd, your claim is finished and we're not going to allow it. That was the basis for the decision.
And there's a few questions that I have on the tail end of this. One is, would Mr. Lloyd have been better off just trying to do it as an individual?
Okay, so he could have done. But the problem with that is that his damages would have been, I don't know, a few £1,000s at most, and he's paying lawyers tens of thousands of pounds to run the case for him. So it doesn't make sense.
Well, and there was a special law firm that was his, they basically hired or were doing the attorney work pro bono, right? And they were looking for some of that $3 billion.
Very interesting that, and it leads on to another point. Very interesting. The way these claims are run as these sort of mass claims, class claims, you'd call them in the States, is that the claimant, Mr. Lloyd, isn't at risk at all, right?
Yeah.
He doesn't have to pay the lawyer's fees. The lawyer's fees are actually funded by a third-party funder who's an investment company, basically. They invest in these claims so that if they win, they get a return on the investment. They take some of the compensation themselves. So it was funded, as we say. The lawyers were paid by the funder. Mr. Lloyd doesn't pay them. And also they have insurance just in case Google win and then come after Mr. Lloyd for their costs. So the insurer will pick up those costs. So it's sort of risk-free for Mr. Lloyd and the class of people. And the people that you can see, you get the people that potentially benefit from this if you win against a Google is the funders and the lawyers who get paid out first. And then the rest of the compensation that's left would go to the affected individuals. So there's go on, sorry. Basically,
Mr. Lloyd didn't really have to do much. He just put his name on the bill and showed up for some court dates. And the lawyers were there. They're it's like private equity lawyers almost, or private equity is putting money into paying these lawyers because they're looking for a return.
An investment firm, basically, yeah. And there are these investment firms which have grown up in the last sort of decade or so, which invest in all sorts of different litigation in return for getting a stake in the compensation if they win. So this is not uncommon, but it's beginning to be applied, as I've explained, to these sort of data protection type claims.
Yeah, and that business is good.
And that's well, as I said, I told you about the claims that were waiting in the wings for this one, and they're all funded on the same model. So
now, do you foresee all those claims that were just sitting around on the outside waiting for this ball to drop? Now they're going to take a different tactical approach. They're going to say, all right, we're not going to try and get the 4.4 million, but we'll get like 100,000 pissed off people to sign some form on the internet that says we don't want our data being used by these people. Yeah. And that is enough. And so that they'll just continue to look for different ways to go after big tech.
Sure. There are two answers to that, which are sort of connected. But the first one is, and it's a technical point, this claim, because it was so old, was decided under the old law, the Data Protection Act from 1998. It wasn't decided under the new act, which is the 2018 Act, which incorporates GDPR, which is the big game changer. And GDPR says you can claim for non-material damage, and everybody's still trying to work out what that means. I told you earlier about regulations and laws having to be interpreted by the courts because nobody can work out what anything means. That has to be worked out. There's an Austrian case going to the Court of Justice in the European Union on this very point, what non-material damage means. So we'll wait for that one, because it might be that the courts say, oh, well, this is a new law. And in fact, you can claim for simply having your rights infringed, even if you've not distressed, you've suffered no loss. So we're waiting on that as well. So we'll see what happens with that. The second point is the one you picked up on. is there a different model for these sorts of claims? The answer is yes, there is. It's called a group litigation order, or GLO. This is where people actively sign up to be part of a class. So the lawyers go out and they advertise and they say, there's been this terrible infringement of your rights. Would you like to sign up and be part of this class? People sign up, and then off you go. The model's the same, basically, funded by a third party, lawyers paid by the third party, not by the people who sign up, and insurance backs the whole thing just in case it all goes horribly wrong. The problem, though, with these GLOs is they do work sometimes. So there was a case settled recently against British Airways, which arose out of a serious data security breach, where British Airways paid out to a GLO class. We don't know what they did because it was all confidential, what they paid out in the end, but they paid out. So that was settled. So it can work. The problem is the lawyers and the funders are all saying it's very difficult to get people to sign up to these schemes, to persuade them to, opt in. And the hit rate for getting people to opt in is between 5 to 10% of the effective class. So if you've got 500,000 people, you're lucky to get 25,000 to 50,000.
Yeah.
Which then, when you multiply the damages by whatever they might say, they all get £1,000 or something. The model starts to break down, because of the costs, and the funder wants their money. You got to pay the insurer, you got to pay the lawyers. Are we getting?
Exactly. You have to pay the people that went out and found those people. I imagine. And
exactly. Yeah. Yes.
Well, this is interesting to me, because I would have thought it would be much more successful, thinking if somebody calls me up and says, hey, you want to be part of this class action lawsuit that we've got going on against Google because they misuse your data, and you don't have to do anything. You just sign right here, put your name, your address, and sign. Yeah. And then you could potentially get $1,000 in a year or 8 years or whatever. Yeah. It's like, well, sure, that sounds like free money to me.
Yeah. Yeah, you would think that, wouldn't you? But apparently it's very difficult to get people to do it. I'm often on the other side of these things, defending them. And it's not easy. I've seen the plaintiff lawyers struggle to sign people up. One of the things that occurs to me about all of this is the reason why people often don't sign up is they just can't be bothered.
Yeah.
I mean, do they really care?
Yeah, exactly.
And so we have this argument at the moment about how do people get access to justice if they can't use these mechanisms or they don't work? And you can't bring the claim on your own because, as I said, it's just not economically viable. But the other side of the argument is, but do people really care? Are they bothered? And some people are, obviously, and are concerned about what big tech companies are doing. But are there enough people who care to do something about this? And that's the problem I think the claimant lawyers have, is getting enough people to care to get them to sign up.
That's so true, because I imagine out of those 4.4 million that Lloyd was trying to represent, there's probably a significant amount that just said, actually, I like having targeted ads, because then I don't get some random hunting ad when I'm a vegetarian.
Yeah. Yeah, I mean that might be right, or maybe when they're approached by lawyers, quite rightly, they don't trust them. So
yeah,
because we're not top of the list of people that are generally trusted in society. We're somewhere just above journalists, I think. So
yeah, that's a great point. So how do you look at this, like this result? What does it mean for the public? And as we're looking at the bigger scheme of things, not having the levers to pull if we do feel hurt.
Sure. I mean, so we're very focused at the moment, because of this case, on bringing court claims. But there's another way, obviously, that we can deal with bad behavior, and that's through regulators. So data protection regulators now have much more powers than they used to because of GDPR and the changes that have taken place. So we mustn't lose sight of the fact that these big tech companies and others who might be behaving badly can be affected by regulation, and the regulators have significant powers to find them. So if you're a concerned individual, you might not want to take on big tech on your own, and I'd warn people about doing that because of what's involved. But you could complain to your regulator, who then could take action. and could go off and investigate and levy fines or take other action. And that has been happening. And there've been some big fines that have come out recently. So that's another way to deal with this sort of behavior.
So let's look at the other side of the coin, though. Sorry for cutting you off. If you want to finish that thought. And the other side of the coin is, do you feel like big tech is going to start or have started doing something differently?
I think they're trying, or at least that's what they're saying in public. So, there are statements made about how they want to be now the good guys on data. And I think they actually see that as something of a selling point, and they're all falling over themselves to say that they respect people's rights. The problem is, and I'll give you an example of this. The problem is that the business model is so ingrained with use of data in the ways that they've been using it for years. It's difficult for them to get off the data drug, as it were, that they've been on. And I'll give you an example of that. The ad tech market. So that's the market which we were talking about, targeted advertising, where you're on a site. We've all been there. You're on a site, and you've been there for like 10 seconds, and then suddenly you get buzzed with an ad, which is for what you're looking at, but it's somebody else, is another provider, and that's the ad tech market. That's real-time bidding. Now that is ingrained in the business model of a lot of these companies. And that is a problem for them, because if they can't do that with the data anymore, and increasingly coming under pressure from regulators to say you can't do this anymore, what are they going to do? How are they going to make their money? Are we going to get to the situation where they're going to have to say to people, look, if you want to use our services now, it's got to be a paid for service, because we can't get the money anymore out of our free business model, which was to use your data, because the regulators won't let us. Well, it's too risky. So now we're gonna say, well, look, if you want to use our pipes and you want to use our platforms, you got to pay for it, like a telecoms company. I mean, this is all has to be worked out. But as I say, they're going to have difficulty, I think, repositioning their business model away from what served them well for the last sort of 15 years.
Yeah, I find it so hard, I guess, just because I've grown up with the free internet and specifically free Google.
Yeah.
Because we've been talking about Google more than anything here, to think, oh, I pay $9.99 to be able to use Google Unlimited.
Yeah.
And how a different company would probably come along and just eat their lunch, because they'll say, well, we don't need ads. We don't need you to pay. We've got a new structure. And so that's interesting to, try and like figure out how that will play out.
But that raises a bigger question, which is whenever these companies begin to be developed, they get gobbled up by the big tech companies.
By Google, yeah.
So they sort of shut down the competition. I'm sorry, I shouldn't quite put it that way, but we see innovative tech companies bought up by the big boys, partly to acquire the very good technology they're creating, but there is a suspicion that it's to close down that sort of competition. But look, the thing about that issue around fines is some of those tech companies may well say, well, look, this is a cost of doing business. I'm prepared to pay a big fine, even if they've caught me out. Fine, I'll pay the fine, but I'll carry on doing something else, which is I shouldn't be doing. So, for example, the biggest fine that we've now got in Europe proposed against Amazon, 746 million euros. Which is an enormous fine in European scales. I know in the States you get fines in the billions, but that is a lot of money.
Yeah.
And that's where the regulators are going. The other thing, though, that regulators can do which is actually more disruptive, is not just fine the companies. They can say to them, you've got to stop using this data. So this data which you've acquired unlawfully, we're going to stop you using it. And if they don't stop using it, then you're getting into the area of, well, we'll go after the executives in the company personally who are, allowing this to happen, and it gets into a whole world of pain. So it's not just fines; it's also the other regulatory powers that regulators have, and this is where the battle is right now.
Wow, yeah, that I hadn't even thought about, and I do know that mentality or that philosophy of, yeah, this is just the cost of doing business. And I always find that to be really slimy or a really dirty way of doing business, but
Yeah.
it happens. So we can't discard it.
Yeah. And we've seen this, for decades. So environmental damage from,
Yeah.
industrial use where companies do bad things, they get the fine, but they keep doing what they're doing because, they can afford the fine and they make more money by acting badly. So, that is a business model.
Yeah, so true. So now tell me about how you helped a client recover an incredible amount of data and information that was unlawfully taken from them.
Oh, this was a case. This was a case about a decade ago. So this was when this whole area of law was just developing, and I had a client who had fallen out with his business partners, and they shared computer systems. And what happened was that the business partners decided to take all of his data for a dispute that was brewing between them, and not tell him. Obviously, they just took it.
Mhm.
And so they took that because they said that to the court. They said later, well, look, we weren't convinced that he was going to hand over what he should hand over when we were in litigation, so we just took it. So
Took
make sure he
everything.
did. Yeah. We said for our client that you can't do this. You can't just sort of go in and take effectively the entire information on a computer system just on the off chance that somebody won't fess up
Give it
later
over.
with
Yeah.
yeah. So look, and that case was groundbreaking because that issue had never really been dealt with before in the English courts anyway, and it went to the Court of Appeal, and we'd had two judgments before. One had been for us and one had been against my client, and so we needed to sort that out, and we took it to the Court of Appeal, and the Court of Appeal agreed with us, and so the information that had been taken had to be given back, and so we resolved it that way. But and that was a pretty groundbreaking case, and has been a precedent ever since for similar sorts of cases.
Yeah. What that makes me think about, like, what other sorts of cases have you seen?
Well, I mean, it's quite common for people to steal data, and people who are leaving a particular business and going to another one and taking client contact details and that sort of thing. It's quite common, and my sort of day-to-day bread and butter work is often trying to stop that happening once we find out about it. The interesting thing, to segue back into data protection, is that in the past we used to do that on the basis of an area of law called breach of confidence. But now we often use data protection law because the information that's taken is often personal data of other people. And the person who's taken it isn't supposed to do that. And so we often rely upon data protection law as well now to say, not only is it breach of confidence or your trade secrets, you're taking trade secrets, you're taking other people's data, and we're going to stop you doing that. And that's often a more powerful ground to get the data back because, the judges or the law wants to protect innocent third parties caught up in a dispute. Sometimes you find that the courts will say, well, this is a dispute between two parties, not quite clear whose rights these are. But when you've got third party rights involved, it definitely helps you to sort of get what you want, which is basically the information back. So that's an example of the way data protection has become much more important in the last decade or so as these cases have developed.
But this doesn't have anything to do with GDPR specifically.
It does in a way, because the person who's taken the information, who is controlling that information now, as the law calls it, has no right to do that. And because they have no right to do that, then data protection law says they've got to stop doing it. They've got to stop processing it, as we say. And processing means even just keeping it. So it does actually impact GDPR. And in theory, you could find a situation where the regulator could get involved. And there have been cases where people have been taken to criminal court for taking this data now, because there's a provision in GDPR which says that, or in our UK Data Protection Act, which says that that's also a criminal offence. So there have been fines issued. I'm not sure anybody's been sent to prison for it, but there've been fines issued by the courts for people doing that sort of thing.
So along the lines of GDPR, I'm anxious to hear what your thoughts are on the cookie policy that seems to follow us around the internet now. And we have to accept all cookies always, or at least click through. There is something, I understand the idea of cookies and wanting to notify people that, hey, there's cookies on this site. I also have thought about, and I've heard about how the default setting or the default like UI that you get when you are looking at these websites is just, the box that's blinking and saying click me is accept all. And then they make it really hard. Some sites make it really easy. They have reject all or accept all, but then other sites, it's like manage settings, and you go through and you got to scroll down all of these and click each one off. And it can be a complete headache just because you want this privacy, right? And so I really would love to hear from your side, like, how do you feel about the cookies and the way that GDPR has been implemented?
Okay, so the cookies in Europe are actually dealt with under a separate piece of legislation, Privacy and Electronic Communications Directive or regulations in this country. But let's leave that to one side. But basically, you're absolutely right that the way it's supposed to work is that unless they're essential cookies, so that means they make the site work, anything that's non-essential, you've got to consent to them, basically. And it's the consent mechanism which is the problem, which is the pain for all of us when we get those boxes coming up. The way things are going in the UK is that there's new legislation coming up probably this year which will say there should be more things which are allowed by way of cookies automatically. So more things should be deemed to be essential, fewer things non-essential. But the non-essential stuff will still be, about consenting to ads and sharing with third parties and all that sort of thing. Now, in relation to the consenting process, the UK regulator is getting increasingly annoyed about people who make it difficult to consent, or who do what you were talking about, which is basically it's not clear whether you're consenting or not consenting. And the default setting should be no consent. And they're increasingly making regulatory rulings about that against, I had a client that happened to recently, where they said it wasn't sufficiently clear that when you clicked on it, it was a consent rather than I don't consent. So I think what's going to happen is two things. I think they're going to reset the rules probably this year. But once they've reset the rules, the regulator will come down hard on anybody who's contravening the rules and not making it very easy to say no, or straightforward to say yes. So I agree with you. I mean, there are all sorts of tricks and traps that people use to sort of, well, I wouldn't say trick you, but make it difficult for you not to consent.
Exactly. And it's not only that, but it's just the amount of time that I've lost since that law was enacted by clicking on these cookies. I'm very surprised that nobody has created an app or something that just goes to the website before it even loads and clicks on the cookies, like yes, accept, or you get to choose on this app or the browser plugin, whatever it is. Like, I want no cookies, or I'm okay with any cookie, and then that goes through and accepts them or rejects them.
I mean, you can do various things through the browser settings. I'm not that technical, but you can do these things. But the problem is sometimes it's quite complicated. But you're right. The solution, it's always seemed to me, the solution is that for people to sort of have a repository which says, this is what I find acceptable. And this is what I don't find acceptable. And that's like a central repository. And then whatever site you're on has to adhere to that, unless you say, actually, for this one, I'm okay with you doing this, or I'm not okay with you doing this. So it's like a default setting, and it just follows you around. But and we might well be headed to that sort of destination. We do it to an extent in relation to something called telephone preference service. I don't know if you've heard of that, but
No.
that's
What's this?
where you effectively you opt out of getting, you know, spam telephone calls.
Oh.
And if you register on that system, and anybody then contacts you, they're supposed to check it before they contact you, see, then that is a big no-no, and they will get fined by the regulator. So it's that sort of centralized, easy to operate system, which we might sort of move towards. But look, everybody's really annoyed about cookie banners, and
Yeah.
I mean, it's just broken, and it just,
it shows, and
yeah,
we'll see. We'll see.
And
how
as a
goes.
lawyer, I get clients asking me lots of questions about that, and you know, sometimes they say, "Oh, we want more people to consent because it's good for us, and can we do this? Can we do that?" And we're sort of saying, you know, you've got to be very careful, A, not to breach the law and get a regulator annoyed, but also not to annoy people.
Yeah.
So, and you know, so we have that conversation a lot with clients.
And actually, so the other thing that's coming up, I mean, I fear that the way that this last law was enacted, like GDPR, and then looking ahead and knowing that the EU is about to release they propose new regulation for 3 different new laws that are around data and also AI and machine learning. And I fear that it's going to just be like manifested like the cookies are. And that's my big fear with the new proposed regulation, that it's like, yes, it's great. It has great intentions and the idea is good, but then in practice, when it actually gets out there, it just annoys people and makes the user interface very difficult.
Yeah, and I think that's right. Look, I mean, the way the EU generally operates is it's certainly in data protection terms and in looking like in terms of use of artificial intelligence, is to be quite prescriptive, and to set quite prescriptive rules. Which the problem with prescriptive rules is then you sort of get a compliance which is not thought through very well, but also by the time you come to comply, often the prescriptive rules are out of date, or they don't follow the real world trend, where people might not be bothered, or they might actually quite like what AI will do for them, or whatever. Do you know what I mean? So I think that is going to be a problem. The other problem I think that you were getting at was that you've got all these different pieces of legislation, GDPR, the AI regulation will come up. We'll probably have an AI law in the UK and elsewhere. You know, privacy and electronic communications, all of these things mashed together, and it just becomes so complicated that it's great for me as a lawyer because it's so complicated, and I'm advising clients till the cows come home. But for clients and importantly individuals whose rights these are, it just becomes too complicated to understand and too complicated for them to enforce, and that's a real problem, I think. So I think you're right. At the moment, there's so many different pieces of legislation flying around and different proposals, and I struggle to keep up with what's going on. And you know, I'm supposed to know what I'm doing. So
yeah, that's true. So there was something you said before, just when you were giving your introduction, about how things really started to kick off when Edward Snowden happened, and I wanted to ask how you saw the overall ecosystem change, and what kind of issues started coming up. Or maybe there was all of a sudden there was that breach of trust. I know I felt like things got exposed, and as an American, we always think that the government is watching us in every moment, but then it was like, actually they kind of are. It's not just conspiracy theory anymore. So yeah, tell me about that.
So that was as I mentioned before, it was a pivotal moment. It was a pivotal moment for 2 reasons. So the first obvious one was the extent, or the allegations in relation to the level of intrusion and spying that was going on. I mean, I mean, or at least the mass gathering of data and it being, in the hands of the government.
Mhm.
But the other thing I think that it caused was not only that intrusion issue, but also I think people finally realized the amount of data and how much it said about you as an individual.
Yeah.
And it's really started that debate as well, not just what governments do with it, but what big tech does with it, or anybody else who gets their hands on it. And it changed the ecosystem in this way. Up to that point, people like me would say to clients, you're gathering this data, you're using it, it's your data. You, the company
Yeah.
that helped, it's your data. It
Interesting.
changed. It changed not overnight, but over the course of a year or two. And as GDPR developed, it changed into a recognition that the companies don't own it. It's
Mm.
owned by the individuals. And in a sense, they hold it on trust for the individuals, trust being the operative word. And they've got to get their head around the fact it's not their data. They don't own it. The individuals own it. That's what GDPR tries to do. I mean, it's not gone all the way there yet, and there's still lots of debates and battles about that. But that was the massive change. And me as a lawyer, I recognized that for the first time, really, that it's about the rights of the individual rather than the rights of the companies who are doing great things with the data. And, some of
Yeah.
them had real societal benefits, but it's still the individual's data. And that, I think, was the moment that the world, as far as I'm concerned, the world I work in, changed.
That's a huge difference going from this is my data because someone came to my website or used my app and I now have it, I now own it, to, oh, this is always and forever going to be the individual's data. I just have it on loan, like you said. And
Yeah.
I really am making sure that whatever I do with that does not lose the trust of the individual so that they do not come back and continue to feed me with all this good data.
Yeah, and the issue really at the moment for society as a whole is that when you have that conversation with, say, it's with a big tech company, but the big tech company says, but we're like a utility. They need us. So they can't vote with their feet. They have to use us. And that is an interesting dynamic, which I talked about earlier in relation to how embedded those companies are in society and the hegemony they have over data. And therefore, how that sort of relationship between, I can go somewhere else or use a different system or whatever, doesn't quite work.
Yeah.
And that's feeding into a different debate, which, at one end of the scale, you've got people like Elizabeth Warren in the States saying it's not enough to regulate those companies. We're going to have to break them up or re-engineer the infrastructure, which would be a massive change. But some people are sort of drawn to that conclusion that we've got to break it up.
Yeah, it's an intense one to think about, and think about how, like you said, we can't just choose the alternative service, because sometimes I think about, for me, I don't use Facebook anymore. I don't use Instagram or any of that. Happily, I'm proudly saying that, right? But there are other ones that I do use, and it's very hard to think like, and especially if you're someone who is getting your livelihood from these different, whether you're like an influencer as your job, it's hard to just say, well, I don't really appreciate the way that they're using my data, so I'm going to go and do something else. It's like, no, that is your job. So you are going to have to find a new job if you try to do something else.
Yeah.
So,
yeah. So, and I'm of the generation where, I wasn't brought up on this stuff, but my kids were, and they'd be horrified if somebody said, "Let's break up the infrastructure," because it just underpins so much of their not only their economic life but their social life.
Yeah,
I mean,
social
it's
interactions.
it's so embedded in the way that they think and behave and the things that they do. Yeah.
That's a great point. So, can you talk to me a little bit about the Red Flag Project?
Oh, the Project Red Card, the football.
Yeah. Yeah,
Yeah.
Project Red Card. That's it. Sorry.
So Lloyd and Google is a case that's finished now by the Supreme Court. Project Red Card is kicking off, if I could use that analogy. It's about footballers who are concerned that their data, so their performance data, how they perform each week and whether they're injured or not, and all that sort of thing, is being shared with the betting and gaming industry. So the betting and gaming industry, there's bets on football matches, and they have in-game betting, and all the statistics are there, but it's all underpinned by data, personal data of the footballers. And the footballers say, we haven't consented to any of this, so we don't want you using it, or in brackets, we'd like some compensation, please, for you using our personal data. And this is a claim so far. About, as I understand it, about 850 footballers have signed up, and it's as I understand it, it's a group litigation setup. So the one I talked about earlier, which is people sign up for it, and then it's funded and all of that sort of thing. So that's just starting. They have written to 17 potential defendants who are betting and gaming companies, saying, we haven't consented to you using our data, so stop using it, or at least pay us if you want to keep using it.
So isn't that data public?
Well, this is a big misunderstanding. People think that if the data is in the public domain, then it can't be personal data. That's not right. It is still personal data. So you're right. I mean, people could observe me in public, and what can I do about that? But it's when they start to economically exploit that information, not that I'd be interesting enough for them to do that, but when they start to economically exploit that information, that data protection rights come into play, and you can start to control that. So, photographers taking images of famous people in day-to-day situations and then publishing that in the newspaper or online, it's the act of publishing which is the thing which engages the data protection rights. And somebody can turn around and say, yeah, I was in a public place, but I didn't give you permission to then use that information, my data, and process it, I publish it to other people. So it's that sort of issue. I mean, look, I have to say the footballers case is a difficult one, right? Because I mean, let's just strip it back to basic principles. Betting and gaming companies usually take a license to use this information. They get the license from the football clubs and the football authorities, okay? And they pay a lot of money for that. And that money goes back into the football clubs and the football authorities to put the football matches on and pay the players' wages. So the players, I would say, are getting at least an indirect payment already through the money that flows through from the betting and gaming companies when they pay the football authorities and the clubs. That is when they're licensed. That's when the betting and gaming companies are licensed. There's a whole subset, though, of betting and gaming companies who don't take an official license, who get this data in other ways. I think they're potentially at risk because they are not paying in, if you like. So oddly, what might happen as a result of this claim is it's not the footballers who will benefit, but those betting and gaming companies that aren't paying the license fees may say, we better pay the license fees, otherwise we're going to have to pay the players. So I think it might actually economically drive more of these betting and gaming companies into actually paying for official feeds of this information rather than getting it unofficially. So
wow. Well, I've got one last question for you. This has been so incredible to chat with you. I've learned a ton just from this hour. And I want to know, Ian, are you a robot?
No, definitely not. Or at least I don't think so. Are we going to talk about existence now? Are we going to say, are we really here? Are we in some other reality? Are we in, and this is where it's going. Are we in some sort of weird metaverse? I don't know. But no, definitely not a robot.
Excellent. Well, thank you, Ian, for coming on here. This has been a blast, man.
Yeah, it was great to speak to you.